All right. Anyone here on Cornerstone? I have Ms. Langford here. Good morning, Ms. Langford.
Good morning, Your Honor. Weston Neal on behalf of Cornerstone.
All right, your P number, if you will, for the record, Mr. Neal.
P number 80307.
All right, and I see Ms. Langford there. Good morning to you, Ms. Langford.
Good morning.
Counsel, go ahead and update me regarding this matter. I know that there was some discussion at the previous hearing on the 23rd, or prior to today's date, I should say. Counsel.
Your Honor, we appeared on the 11th. Co-counsel of mine, Michael Mamet, at the firm, spoke with the defendant, and per my understanding, she was to provide financial information to supplement her motion for installment payments. We've not received anything. So more or less, we were in the same spot we were last time.
Right. So Ms. Langford, I recall that now. Tell me what's going on here. I know I denied the petition on a couple of occasions or before, but you're asking, I think, to make payments of $125 a month or something. But go ahead and talk to me, Ms. Langford.
Yes, I did provide them documentation. I actually came to the office and put it in the Dropbox. I spoke with the receptionist, so they have the documents there. I'm not sure why he hasn't obtained them.
So when did you do that, Ms. Langford?
Today is Monday. I did that on Wednesday.
So, Counsel, you have any way of checking up on that? She indicates, as you heard, that she's dropped those documents.
Your Honor, we have nothing scanned into the system. If the court wants to pass on this matter, I can go inquire right now with the our secretary and see if there's anything. But given that it's not in the system, I don't believe that's likely.
All right. Well, let's see if there's that kind of breakdown. Ms. Langford, I'm going to come back to this matter. Yes, Mr. Neal is going to try to research where the documents might be that you have dropped off. I'll come right back to you, matter. Sure.
Okay.
The court now calls
Thank you, Your Honor. I'll be right back.
Yes, sir. The court calls case number 22-179-657. This is Mimic Insurance versus Marathon Garnishment, Best Buy Service Incorporated. I think that's a garnish defendant in this matter while waiting out. Your appearance at this time for the plaintiff. For Mimic Insurance, are you there? All right, I'm looking now in the file and I do see that there is a request that the court would adjourn the pretrial hearing, and the parties have stipulated to the same, and they've asked for an additional 21 days. Do I have either of those parties on this Zoom at this time? All right, I will go ahead and grant the adjournment in this matter, and the court will set a new date for this case. All right, the court now calls case number 22-182-312. This is ZMC Pharmacy LLC versus Smart. The matter is before the court, set on for a pretrial conference. Your appearance at this time for ZMC.
Good morning, Your Honor. Wilma Zame on behalf of plaintiff P8427.
All right, thank you, counsel. Good morning to you. For Smart, please.
Good morning, Your Honor. Mitchell Myers on behalf of defendant P82917 under the firm appearance rule.
All right, thank you, Mr. Myers. Good morning to you as well, sir. All right, so I think I put a schedule in order in place previously in this matter. Yeah, that was back last year. I know that there was some discovery issues regarding some interrogatories. Go ahead and plaintiff, go ahead and update me as to where you think this matter is at this time.
The last thing I see in my file is that there was an offer made, and then I think we had countered, but it doesn't look like there was much of any discussion after that.
Right, Counsel?
Yeah, that's correct, Your Honor. There was settlement offer made, but the parties just aren't quite there on the numbers right now.
All right, so, what would you like the court to do? You want me to set this on for trial, or do you want to, continue trying, perhaps send it to some type of mediation or facilitation, what's your thought?
Yes, Your Honor. Defendant thinks that this would be a good candidate for case evaluation if plaintiff is willing to do that as well.
Yeah, I think case evaluation might help us resolve this.
All right. All right, so what I'm going to do is I will go ahead and issue an order for case evaluation regarding this matter. You'll get that from me in the next couple of days. I'm going to go ahead then and set the matter over. I'm going to go ahead and set it for the 9th of March. I'm really optimistic that I'll be able to get an update by that time, March 9. And that's going to be at 10 o'clock a.m. 10 o'clock a.m. You will get and the notice that you're going to get in the next couple of days, that subsequent date on it, that will be treated as a final pretrial conference date, 3/9/23, 10 o'clock a.m. So you'll get an order from me for some type of facilitation and mediation in this matter for March 9, 23. Right. I wish the two of you well. Good day to you.
Thank you,
Thank you, Your Honor.
The court now calls case number 2021-725. This is Henry Ford Health Systems versus Citizens Insurance Company of Midwest. Today is the date time set for a pretrial conference regarding this matter. Your appearance for the plaintiff, please.
Good morning, Your Honor. Stefania Desmoni on behalf of Plaintiff Henry Ford.
Your P number for the record, if you will, counsel.
74277.
Thank you, counsel. Good morning to you, ma'am. For the defendant citizens in this matter, please.
Your Honor, Eric Duenas on behalf of Citizens, P57434.
All right, thank you, Councilman. Good morning to you as well. I see that this is the date for pretrial conference, also the cutoff of discovery. Somebody update me on where you are in this regard. I do see a document filed in December, defendant's motion for adjournment of the scheduling order dates. And we can certainly address that at this time, but go ahead and update me. Let's start with you then, counsel for defendant in this matter.
So, Your Honor, this is an issue of whether or not Citizens was assigned to cover a PIP claim through the assigned claims plan, and we had to find if there was insurance. And there were 3 people named on the police report. We subpoenaed them all. It was adjourned once. We did actually just take the depositions last week, and there was a statement that there was insurance in place and that they would give us all the information for the insurance with Progressive at the time of the accident. And we have not heard back from the person yet. My office is following up. And we really just got to verify whether that was an accurate statement. Let's put it that way. Sometimes it is, sometimes it's not. So we're getting really close to where we need to be. Everything's moving along fine. We're all, both attorneys, both offices are working together well. So we just need a little more time, and then hopefully we won't have to come back and bother you.
Sounds good. All right, Madam Counsel, anything?
Oh, Your Honor, we're not opposing the motion to adjourn dates. And it is my understanding that we are still investigating whether or not the Progressive policy actually was in effect on the date of loss, which, as defense counsel said, could very well be that it wasn't actually in effect. So I think that given the deposition was only about a week ago or so, we haven't been able to confirm that yet. However, our position is still that, the MECP here does owe the emergency room bills in the event that there is no insurance. So, but we're not opposing adjournment at this time.
All right, sounds good. I'm glad to hear that things are moving along and there's nothing that's like stuck in the mud trying to follow the normal course of discovery. And that's kind of why we set this up on like a 60-day order to kind of get at the heart of it. And then if you need some more time, then it makes sense. So I'm going to go ahead. I think what I'm hearing here, probably I take another look at it in 45 days. And of course, if you come up with something before that time, then I'll be glad to hear it sooner on any motion to bring it to a sooner date. So let's go ahead now and set this for the 16th, actually the 15th of March, 3/15, 22. And I'm going to simply and that'll be at 9:45. I'm going to treat that as a second pretrial date. And hopefully you'll be able to get the depths or anything like that resolved. Discovery will remain open through that date. And of course, if you find out that insurance issue, then that will take the case in one direction. If there's no insurance, then we know that this case continues on in the manner that it's in. All right, so I'll see you on the 15th of March, 9:45 a.m. I wish you all a good time.
Thank you, Judge. Judge, do you need an order for that, or is the court going to do that?
No, I'm going to send out an order.
Excellent. Thank you.
I'm going to send out an order with the trial date contained, so I get the next action date as well as the extension of discovery and the schedule.
Okay. Have a great day. Thank you.
Thank you, Judge.
Mr. Neal, any information at this time, sir?
Your Honor, I did check with our secretary and I looked in the Dropbox. There's nothing in the Dropbox, which is natural. It would be cleared out daily. The secretary does not recall speaking to anyone matching Ms. Langford's description.
All right. So, Ms. Langford, I muted you because there was a sound coming while I was hearing other cases. Let me have you unmute yourself now, ma'am.
Okay, hi, yes, Your Honor, I did drop it off and I also took a picture of the Dropbox and the information that I put into the Dropbox, just so I can have proof.
No. All right.
I went to the office on Franklin Road in Southfield, Michigan.
That would be that'd be the correct area. So, Counsel, you want to take a moment in a breakout room to see if there's any way to determine, because ma'am, you're asking to make a payment of $125 a month. Is that true?
Correct.
And I know that this is a judgment that was entered at $10,000. And is there a garnishment in place at this time, Ms. Langford?
Yes, the garnishment is in place and they have took a total of $2,000, Your Honor, in the past 2 months, which has caused me to get behind on my bills and everything.
All right. Well, with the judgment being in place, that garnishment is what it is. I mean, that's the kind of thing that happens in these type of situations. So how much is taken from you per pay period, ma'am?
I get paid weekly. They're taking $215 every week.
So basically getting hit for $860 a month.
Yes.
All right, Counsel, you want to talk about this in a breakout room? You see, the difference between 860 and 125, I suppose, is what's the concern here. If I leave the garnishment in place, then of course that's hitting you at that amount versus taking away $700 a month from the rights of garnishment. All right, so Mr. Neal, you want to take a moment to talk with Ms. Langford and see if you can reach some accommodation on this?
Yeah, absolutely, Your Honor.
I'll make some decision and try to figure it out under the circumstances. If that judgment wasn't as high as it is, that would make this case a whole lot easier. But with the judgment being the amount it is, that's a part of the challenge here. So Ms. Langford, I'm going to send you to a breakout room, Mr. Neal. Let's try to figure this out.
Your Honor, can I say something real fast?
Yeah.
Okay, so last time we were here, I got in the breakout room with the other guy and we couldn't come to it.
You know, I
I'm
know
sorry.
that, right?
Okay,
But, if we can't find a way forward, then I have to, figure this out, and one of those options is to leave the garnishment in place. And I really don't want to do that, so, try and talk about it and see if you can control this a little bit. And then I'll talk to the parties when they come back in. You need to try and find a way. If you don't, I'll figure something out. But the challenge here is that there is a $10,000 judgment in place, and the law allows that, as well as other garnishments, and so there has to be something extraordinary for me to trim that down. And I think it's reasonable to do that. It's just a matter of where that number should be. So that's why I sent you the breakout room again, just to see if you can do anything. But if not, like I said, I'll figure it out. Okay.
okay.
All right, cool. So go ahead and click in. I'll send both of you the notification, and I'll come back to you, Matt. All right, thank you for your patience, all. This is case number 22191011. This is Anesthesia Services Affiliates versus City of Detroit. The matter is before the court for a pretrial conference, I think an adjourned pretrial conference date. Your appearance for anesthesia, please.
Good morning, Your Honor. Jeff Gold standing in on behalf of Jared Anthony.
All right, your P number, if you will, Mr. Gold.
Apologies, P number 83699.
All right, thank you, Counsel. Good morning to you, sir. For the City of Detroit, Counsel.
Good morning, Your Honor. Alfred Ashew on behalf of defendant P82536.
Thank you, Mr. Ashew, and good morning to you as well, sir. All right, so I'm kind of browsing through here to see why or if we had a pretrial date on the 10th. I don't recall, but anyway, we're here today. Somebody update me. Where is this case at this point?
Your Honor, as I understand it, this is our first time appearing for a pretrial in this matter. For whatever reason, we did not receive the pretrial order with the scheduling order. So we haven't exchanged any discovery in this matter as of yet. So at this point, I would just ask for a little bit more time so that the parties can exchange discovery and see, evaluate the merits of the case.
And that's my understanding as well, Your Honor. I took a look through my file. I didn't find any scheduling order dates, any discovery dates or anything like that issued by the court on this one.
So I sent that out on or about November the 15th. So you even, you never got any information on this case that besides from the court. Wow. All right, so gentlemen, I'm going to go ahead and reset that. I don't know what happened. We're gonna make sure that order gets out in the mail today. And so in restructuring a new date on this 60 days hence, I'm going to put this in the. Let me go ahead and put it at 27th of March. Yeah, March 27th, 2023, and that's going to be at 9:30 a.m. And what you'll get is a scheduling order from me allowing discovery through that date and other provisions under items 1 to 9. That'll be in the scheduling order, and we'll get that out in the mail today. 3/27/23 is the next action date. Discovery is through that date, and that time will be 9:30. We'll get an order from you in the next few days.
Thank you, Your Honor. Just to confirm, you said March 27th at 9:30?
That's correct, sir.
Thank you.
Thank you, Your Honor.
Thank you. To, both.
Have a good day.
All right, the court is calling 22196771. This is Revival Physical Therapy LLC versus City of Detroit. The matter is before the court for a scheduling conference. Your appearance for Revival Physical, please. Anybody here for Revival Physical Therapy? All right, let me have the appearance for the City of Detroit.
Good morning, Your Honor. Ben Patterson on behalf of defendant City of Detroit, P85118.
All right, thank you, Mr. Patterson. Of course, I received the city's answer, and other items regarding this matter, and so that's why we set it up for today. Have you spoken with anyone on the other side who might be representing the plaintiff in this matter?
I have exchanged some emails with an attorney named Ryan Jurgensen or Jurgen. I sent him the bus video and he had made a demand.
All right, so I don't know why he's not here. My inclination is to go ahead. It seems like you've been making some progress. My inclination is to go ahead and set up a scheduling order regarding this matter and mail out a copy to him as well as to yourself, and then let's see where the case is in about 60 days.
All right.
All right, so
Yeah, this is our first.
Yeah, yes, sir. Go ahead.
Yeah, yeah, this is our first appearance on the case, so setting a scheduling order would make sense.
Yeah, so I'll go ahead and set it up. And I kind of put that out there because, you know, to see if you were asking for dismissal at this time.
Well, Your Honor, I guess I know the court procedures call for that. I will defer to Your Honor's good judgment on whether to dismiss or not.
Right. I was kind of talking under the table a little bit around that, so I'll drive right into the court's position on this under these circumstances would be that I wouldn't grant a motion to dismiss at this time. So I'll go ahead and set up the scheduling order, bringing this matter back on the 27th of March, 3/27/23 at 9:45 a.m. You'll get a scheduling order. That scheduling order will have the notice of hearing, the next action dates contained in the order, and that will include the 3/27 date. It will be in the order.
Would 3/27 be the date for any motions to be heard?
And motions can be heard under provision number 6 of the scheduling order. Yes, sir.
Thank you, Your Honor.
Thank you, sir. Good day to you.
You too.
All right, the court now calls case number 22-198356. This is Bank of America versus Sherman Reynolds. The matter is before the court pursuant to the court scheduling a status and scheduling conference. Your appearance for Bank of America, please.
Good morning, Judge Coleman. Cezanne Barda, P65425 on behalf of Bank of America.
Thank you, Mr. Barda. Good morning to you, sir. I'm looking now for Mr. Sherman Reynolds. Please, sir. Good morning to you.
Good morning, Jeff.
All right. Thank you for being here, Mr. Reynolds. All right, so of course I brought this up for a status conference because I received something from Mr. Sherman that was treated as an answer, and it's styled as an answer to complaint, but it looks more in the form of a letter. So let me try to drill down on what the issue is here, whether there is really a dispute regarding the indebtedness. Mr. Sherman, tell me, is there really a dispute regarding whether or not this is an obligation?
Repeat, Judge, can you repeat that question? It sounds like you asked if it was. Can you repeat your question, please?
Yeah, here's what I'm getting at. When you sent your document in that started as answer, Mr. Reynolds, you were talking about the debt being charged off and canceled by the creditor, et cetera. And those kinds of things, or charge offs and what have you, they do occur in the course of matters being closed out in ways. But that in and of itself does not mean that the debt has been canceled. You would have to have something in writing or some written document that would have been sent to you saying that that your obligations on this debt has been waived, or that the entity holding the debt has made a decision that they will not that they do not wish to collect the debt from. And so I guess my question has more to do with whether or not you have any document or anything along those lines that shows that they sent you something in writing canceling this debt.
Oh, no, I don't have anything in writing from Bank of America in regards to that. What I had asked for in regards to the information I received from, I think it was I'm noticing that there's discrepancies in regards to who's sending the information. On the summons, there was a Weber and Olson PLC. And then I noticed in regards to the notice to appear, there was a Jeffrey S. Werber who was listed. And so that's why I'm here today. I was asking for, in addition to just validity or proof of the contract, sir, and also just understanding, how did they get my information? So it's a form of validation because I did want to understand how did they come to that amount, and then if it was accurate. And then in addition to that, I just asked a couple of other points to make sure that everything was accurate and forthcoming.
All right, got it. Mr. Barber?
Yes, sir.
Good thoughts in that regard. The gentleman is saying that the pathway of this debt leaves some concerns for him. Tell me about this. I mean, it looks like this arises as a result of a Bank of America card or something that was used, Mr. Sherman, that there were certain debts that approved on that card, and ultimately the plaintiff is seeking to recover for the amounts that approved on the card. And last, well, one of the bills that I see attached in this matter dates to for the second 2021, and it shows at that time that there was an outstanding debt of $13,900, and that's directed to the address on Fairview, and that seems to be the same address that you are using at the current time as well. So it seems like something that you might have been aware of, something that was ongoing. This doesn't seem like something that's a big shocker, right? Mr. Bartlett, anything at this point, sir?
No, Your Honor, I think what you're saying is correct. I mean, we have an account application, we have billing statements from Bank of America, who is a direct client, so we don't need chain of title documents. They are a direct client. We're gonna have a direct affidavit from the client. We have billing statements from 2014 to 2020. It's 6 years every single month. Our motion for summary, which would be our next step, will have every single statement attached to it. I do believe is validation, although we do have to comply by FDCPA rules and regulations. We have to send them what we have to validate. Like you said, this should not be a surprise when you don't make your payments timely. Interest, fees, they add up. There's a statement balance. I believe Mr. Reynolds should be settling this matter for less with us. However, if we have to come before you on a motion for summary disposition, obviously we'll do so.
The reason that you hit upon one of the reasons that I was asking these questions, and that is to see if maybe the parties have some room to talk about settling this. Because if it's a debt that can be tracked back, obviously interest has accrued and so on and so forth, there may be room for the parties to talk about it and come up with a number that is more accommodating than the number that is before the court at this time. Mr. Reynolds, would you wish to at least take a moment to try and talk about that?
So just to be clear, sir, Judge Coleman, I was asking if they can provide that information. That's what I submitted and sent to them, to the attorney that was listed there. So I haven't received that.
Yeah, let me stop you for a moment. You already told me that. My question is in light of the, my question to you is in light of the reality that seems to be here, that you had an ongoing obligation with Bank of America. Do you think it's worthwhile to try to talk this down some and try to reach a resolution of the matter? That's what seems more reasonable. If I get a motion for some disposition, and I rule upon that motion, then typically whatever the number is that the plaintiff is bringing in at that time, if you lose on that motion, then you become obligated on that entire amount. Whereas if you can talk about it, then maybe you can come up with an accommodation. Unless I guess the part of it here is if you feel that there is nothing on this obligation that you may owe, then it's not worth talking about it. But if you feel that there is some of this that you may owe something, then it might be worth talking about. And the sooner on those kind of things, I guess, I think are better. Any thoughts about that, Mr. Randall? Anything you want to say?
Well, I did understand what you're saying to a point, but I did make a specific request in the time that was, required, and I hadn't received the answer like you reinstated. And then all I'm asking now is just for the details, so that way we can be clear that if there's an amount that's owed, how did they get my information? That was one thing that I was kind of concerned about. And if there was any type of, contract between them, like a Bank of America, and now it seems like there's another additional party with the gentleman who's on the Zoom call with us now.
No, that would not be true. That's the attorney's office that represents Bank of America. The only parties involved in this case is Bank of America and Sherman Reynolds.
And Your Honor, if I may real quickly, I know practicing collection law for 20 straight years, I can tell from an answer when I read one and from speaking to this gentleman this morning that I do not believe it would be fruitful for you to put us in a breakout room to try to discuss, because you keep asking, is there room for negotiations? And he continuously bypasses your question and starts talking about not receiving certain information that he's looking for, when in fact he had a debt with Bank of America, charged the card, didn't pay it back, and owes a balance. It's really easy, and somehow it's becoming difficult.
Well, Mr. Barter, I did know that you and the gentleman had spoken earlier this morning. Otherwise, I would not have made the inquiries.
No, I'm sorry, Your Honor. We did not speak. We did not.
Said that, well, when you spoke earlier. All right. And in any event, it is clear to me now. Thank you, Mr. Barter. It is clear to me now. I read the answer that Mr. Reynolds sent, and of course I reviewed the complaint in this matter. And I know that you have been practicing in debt collection for the last 20-some years. I've had some dealings with debt collections as a judge for the last 30 years. So the reason that I was driving this home to start talking about numbers is because the workup to receiving verification of a debt that one has had that has been ongoing for years, that's an act in futility. It's not going to, it's going to end up being that there is a debt. And if it's going to end up being that there is a debt, then the prudent thing to do is to say, how can I figure out a way to lessen the amount of that debt accrual? And that's the only reason the court took as much time as it did to talk about this. So what I'm going to set it up is I'll set it up for a discovery, and I'll allow for open discovery over the next 60 days, exchange of information. I'll set a motion hearing date on this matter, and that date is going to be the 28th of March 28th at 9:30 a.m. My order will allow discovery to be open through that date, and it will also set that date as the motion hearing date, so long as the notice of the motion is given at least 10 days before the hearing date. So if you file a motion and you give the other side at least 10 days before the hearing date to respond, I will hear the motion on March 28, 2023 at 9:30 a.m. All right, you'll get that scheduling order in the mail from me in the next few days, Council and Mr. Reynolds. Good day to both of you.
Thank you, Your Honor. Have a great day.
All right, Mr. Neal and Ms. Langford, I see that you're back. This is the case, the suffix is 0656 Cornerstone versus Langford. The parties have already indicated their presence in this matter. The court did send the parties to a breakout room to discuss the possibility of some resolve in this matter, where there is an outstanding judgment that was entered in the $10,000 range. There was judgment granted in this matter by summary disposition. I believe there was a payment order that was in place, looking for that at some point in this matter. Just one moment, let me just take a quick look here. All right, no, I'm seeing that there was garnishments that were made, and then there was a petition for installments motion that was denied. It was requesting, I think, $20, and the court determined that amount was substantially too low, given that the judgment amount in this matter was in the nature of $10,000. All right. So update me on your discussions, and let me see if I can get to the bottom of this, counsel, and then I'll come to you this time.
Your Honor, we did speak at the breakout room. Ms. Langford was kind enough to kind of give me a verbal breakdown of what her financial picture looks like. We were not able to come to a finalized agreement of any kind regarding a payment plan. Hence, we headed back into the courtroom to let Your Honor know that we would just be proceeding with arguments.
Thank you. Counsel, I received your response to the defendant's motion for installment payments. And at the conclusion of the matter, you were asking that the court would set up an installment situation where it would be $200 bi-weekly for a total of $400 a month, which would represent less than half of the garnished amount, correct?
That is correct, Your Honor.
All right. Ms. Langford, go ahead and talk to me, ma'am.
Yes, I was trying to explain to him my whole breakdown of my bills and everything. And currently, my after taxes, my checks are only like $700 after taxes. So that totals me out to what, $2,800 a month. I can't afford to pay $400 a month to him, and pay my bills and take care of my kids, and everything is impossible. I'm a single parent, and that's hard. I'm already behind on my bills right now because they took a total of $2,000 in the past 2 months. So that's why I agreed to the $125. I even told the last guy that I could probably do $150 a month.
And of course, that the hard part of this, ma'am, is if I leave the garnishment in place, you got to do 860. That's the problem. All right. Mr. Neal, anything?
Your Honor, just one point of clarification on the payment discussion that we had prior. The response to our motion responding to the motion for installment payments, we did request it be via a reduced garnishment for $200 bi-weekly. Defendant did indicate to me that she's paid weekly, I believe. We would just modify that to $100 weekly to match that same amount per month.
All right. Anything else you wanted to tell me at this time, Ms. Lane?
No, I just was trying to see if I could stop this garnishment and stop them from, because I think I just received something also stating that they were trying to intercept income taxes too. So it's just a lot. I was just trying to figure out if we can kind of get a payment plan going on. That way I can still maintain my bills and take care of my family.
All right, thank you, ma'am. All right, the court has considered the arguments with regard to the petition for installment payments, the objection to the same. The court has taken into consideration the amount of the judgment, the amount of the current garnishment, the wages, resources, the obligations that Ms. Langford has indicated that she has, and again, the amount of the judgment that is existing in this case. I am going to grant the relief of a reduced garnishment in this matter. I'm going to set the payments at $200 a month, reviewable in 6 months. I'll reduce the garnishment to $200 a month, and that can be set up as a $50 per week until I review this in 6 months. And my review at that time is to determine whether or not the amount could or should be increased. My inclination is to keep it at 200, but if indeed there is a showing that the amount could be increased, I'll consider that on the 6-month review. at this time, I'll sign an order reducing the garnishment to a maximum of $200 a month at a rate of $50 per week as a garnishment amount. So ordered.
Your Honor, I could prepare the order. Is there an email I could submit that to?
Yes, thank you, Councilman, and please send that to Carmen, C-A-R-M-E-N-S, C-A-R-M-E-N .banks, B-A-N-K-S, Carmen.banks at 36districtcourt.org. Council, if you could get that over to me quickly. I know that Ms. Langford wants to get off of the garnish rate that she's on now. So as quick as you can get that to me, I'll get it back out to you and get a copy to her so she can take it to her employer and they can.
Thank you, Your Honor. I should be able to get that over this morning.
All right, thank you. I'll sign it and get it right back.
I have a question, Your Honor. As far as, that, so I'm going to do the 200 a month and then we're going to review it in 6 months. As far as them taking the 2,000 in the past 2 months, is there any way that I could start the payments to give me time to kind of catch up?
Well, those funds that have been taken are released to the plaintiff. The second thing is that as far as catching up, that's why I'm talking about the gentleman getting the order over to me as soon as possible, because until that order is in place, they're going to keep taking at the rate that they've been taking. So the big thing here is the step number one is the $50 starts occurring right away, but that $50 means that you're not getting hit with the garnishment of $220 or $215. So it goes down from $215 to $50. So,
Okay, so they're still going to garnish. It's just going to be 50.
it's just exactly. And here's one of the things that you can do to help your cause on this, Ms. Langford. If you know how, text, strike that, chat your email address to me. And as soon as I sign that order, I'll have my clerk to email a copy of the order to you, take that to your payroll department. And that'll get you to that result as quickly as possible.
Okay, so would they still be able to intercept my income taxes or would that be on hold as well?
Yes, ma'am. The income tax intercept is a separate type of garnishment. And even if they're garnishing your wages, they can still intercept the income tax return. They can also go after a bank account. But typically what happens is that when you're paying on a installment plan, typically the plaintiff does not go after bank accounts and things like that. Usually they just accept the payment that is being made in that regard. That they do not typically waive their right to go after the state income tax return. They can't garnish the federal, they can't garnish the city, they can't garnish the state income tax return. So those are two things you can expect, is that the garnishment but at the reduced rate of $50 a week, and the garnishment against the state income tax return, they have the right to do that and they're likely to continue.
Okay.
All right. So chat your email address so that I can get a copy of that order to you so that you can get that order to the to your payroll department. Because as soon as they get that order, they will stop garnishing at the rate they're garnishing at the present time. Council, set the date in the order that you're going to send. The review date. The review date is going to be approximately 6 months in. So I'm setting that date for. Go ahead and set it for June the 27th. June 27th, 2023, and that's going to be at 9 o'clock. It's right at 9:30 a.m. June 27th, 9:30 a.m. The review on the installment order.
Will do, Your Honor.
Thank you, Council. All right, good day.
Thank you, Your Honor.
Thank you.